So very good morning to all of you. So attendance please. Mukul Swami, Parth Narendra, Prakash Chaudhary, Pushpendra Pal Singh, Rakesh Raika
Yes,
and
sir. Prakash sir.
Deepak.
Yes, sir.
So let's start the class.
Sir, Parth here, sir.
Yeah, Parth Narendra bhai, I just announced your name also, dear. Thank you. So let us begin. So yesterday we studied about the Sales of Goods Act. Okay, so we'll be continuing with the same thing today too. So let us now proceed further. Yeah. So Sale of Goods Act, particularly we just discussed about the overview yesterday. What are the ingredients of the contract of sale, and further the introduction, which includes your definitions that why and how this Sale of Goods Act is a special act. Okay. So this all we studied yesterday itself, and today we are going to proceed further with certain other things. So we talked about all the definitions, containing types of deliveries we had, and then document of title of goods. I hope you have done your homework also. And then we have come to other definitions like property or ownership, and then insolvent, price, quality of goods, and then we discussed about sale and agreement to sale, which is also one of the very important thing to be done. And when the agreement to sale become the sale, okay, so it is there are certain elements of which we have to which we have discussed yesterday, and then afterwards we discussed about certain distinctions between the sale and agreement to sale. Now how this contract of sale is made was also discussed in detail, and analysis of this was done, that how this has been, how you will interpret the or summarize the section. So today's session 22, that is conditions and warranties. So we will be doing this further. So anyone of you, can you please tell me what is a condition and what is a warranty, or what is a guarantee given? Anyone, any vague idea about it? So please participate. Come on. So nothing said from you will be wrong. So come on, I will find something good in that too. Come on, even if you are wrong to some extent. So please tell me, any one of you. Yes. No one? Okay. So at the time of selling, see, conditions are what sometimes we just we have heard about. Okay, this particular thing is in warranty period. If it will damage, the company will either change it or repair it for free of cost, or will make good it to us, and all this happens. Okay. So this is something which is related to your this condition, or you can say the warranty or the guarantee. Guarantee is sometimes which is taken as that if something will happen, if it will stop working, then what we will be doing is we will get the replacement of the same. Okay. So at the time of selling and goods, but here the context is a bit different. So whenever we have and sometimes even the seller induces us to buy certain things, putting certain facilities along with. So at the time of selling goods, a seller usually makes certain statement or representation with a view to induce the intending buyer to purchase the goods. Such representations are generally about the nature and the quality of goods, and about their fitness of buyers to purchase. Whether the goods will fit my purpose or not, the buyer is having all the right to ask to the seller that whether it will be fitting my purpose or what it will be. Okay, so definitely those the things which are intended to be sold should fit the purpose of the buyer, and if the seller assures that it will fit the purpose, then the buyer will buy the things. Okay, so when these statements or representation do not form a part of the contract of sale, they are not relevant and have no legal effects of the on the contract. But when then at that time, so there are certain instances when these are not at all a part of the contract or nothing like that, it will not bound. But sometimes these form a part of the contract and the buyer relies upon them, and relying upon them, finding them relevant, then only the things will be having the legal effect on the contract as such. So a representation which forms a part of the contract of sales and affects the contract is called stipulation. So it is something stipulation. Stipulation means certain condition, or you can say, if this will happen, I am ready to buy this because my purpose is this, and if this will not be there, then it will I will not be able to fulfill my purpose, and accordingly will not be able to buy it. So, however, every stipulation is not important, but these stipulations are very important, because of the virtue of this stipulation only, sometimes we purchase the goods. Okay, so a stipulation in the contract of sale with reference to the goods which are subject thereof may be condition or warranty. So it can be condition or it can be warranty. Condition means that if it is fulfilled, then only I will purchase. So something which is essential part of the contract, and something which is collateral. So a condition and stipulations are essential to the main purpose of the contract, the breach of which give rise to the right to treat the contract as reputed. Okay, and the warranty is a stipulation which is collateral to the main purpose of the contract, the breach of which gives rise to the claim for damages, but not a right to reject the goods or treat the contract as repudiated. So condition, here we can say the condition is more powerful than that of the warranty. So condition is given in section 12.2 and warranty is given in section 12.3. So warranty is W. So 3, if you see, there is some W in 3 also. Okay, so warranty is 3 and condition is 2. Okay, it is a stipulation. First is the main purpose of the contract, and second is stipulation. So this way I learned the sections. You may also learn it in this way. Okay, whether a stipulation in a contract of sale is a condition or warranty, it depends on the case-to-case basis, or the way in which the contract has been formed or it has been constructed. So stipulation may be a condition, though called a warranty in the contract. Okay, so it may be condition, but it may be a condition, but it is again, it can be treated as a warranty also. So we will see the things. So for example, Ram consults Shyam, okay, a motor car dealer, for a car suitable for touring purpose to promote the sale of his product. Okay, so actually Shyam actually wants a motor car which can be used for the promotion of the sale of his product. You might have seen this Maruti Suzuki Omni and all that placed at certain places. Okay, so that the purpose is being fulfilled by, but such purpose is not fulfilled by other cars, and Ram is not at all actually aware of that which car will fulfill his purpose. So Shyam suggested Maruti, and Ram accordingly buys from Shyam. The car turns out to be unfit. Why? Because he actually gave him Maruti Alto, which is not fulfilling the purpose. The Maruti Omni was to be given. Okay, so the car turns out to be unfit for the touring purpose and also for promoting his sales item. So here the term car should be suitable for touring purposes. It is a condition to the contract because he has put it as such. So it is vital that its non-fulfillment defeats the very purpose of which the Ram purchases the car. Ram is therefore entitled to reject the car and have the refund of the price as such. Okay, so in that case, because the condition is not fulfilled, it is something which is not, it is a condition to the contract, and he actually proposed his condition in front of the car dealer and relied totally upon the condition which was according to his need, which was given to him as given by him. The thing should fulfill that. Okay, so again, let us assume that Ram buys a new Maruti car from the showroom, and the car is guaranteed against any manufacturing defect under the normal usage for a period of 1 year from the date of original purchase, and in the event of any manufacturing defect, there is a warranty for replacement of defective part if it cannot be repaired. Okay, so this is something which is again. So after 6 months, Ram finds that the horn of the car is not working. Here, in this case, he cannot terminate the contract. What he can do is he can get the things repaired. So the manufacturer can either get it repaired or replace it with the new horn. Ram gets the right to claim the damages if any suffered by him but not the right of the repudiation. For example, he actually went into a small accident because he had to use the horn and the horn was not working. So for that particular purpose, he can claim for the damages. He can file a suit against the manufacturer that because your horn was not working and it is in the warranty period and I met with an accident, so I can file a suit against you for that. Okay, but then the court will decide to what extent he will be given the compensation. But at this time, particularly when he cannot repudiate the contract because horn is not working. Okay, so this is something which is related to warranty. Okay. Now next is your difference between condition and warranty. So here comes your assignment. So Shaurya, please note down. Assignment is that everyone has to write the difference between condition and the warranty. So here there are three differences I have written. You can elaborate more differences also. The more you will apply your brain, you can find some more differences. So first is it is a condition is essential to the main purpose, whereas warranty is an collateral to the main purpose. Second is right of the breach. The aggrieved party can repudiate the contract or the claim of damages both in the case of breach of the condition. Here only the damages can be claimed, the repudiation of contract cannot be done. So conversion of stipulation, a breach of condition may be treated as a breach of warranty, but breach of warranty cannot be treated as a breach of condition. Okay, so these are the three differences which I have mentioned over here as given in the books, but you can write more differences. As just now I have told you, this is dealt under section 12.2 of the contract. Condition is under section 12.2, warranty is under section 12.3. Okay, so likewise, if you will go into it, definitely you will find some more differences. So let me see how many differences do you write. Okay, so this is the assignment. Shaurya, noted? Please put it on the group. Shaurya, are you there? Shaurya, not there? Okay. So I'm putting it over here. Distinguish between conditions and warranties. Yeah. So let's proceed now then. Hope the presentation is visible to all of you.
Yes, sir. Yes, sir.
Fine. So when condition may be treated as a warranty, where the contract of sale is subject to any condition to be fulfilled by the seller, the buyer may waive the condition or elect to treat the breach of condition as a breach of warranty and not on the ground of treating the contract as repudiated. So what can be done in condition is that there are two things. One can repudiate the contract and second thing, he can claim the damages. So if there is some condition and the person is only just applying the damages part, he is not repudiating the contract, so it is upon him whether he should treat the condition as a warranty or not. So this is one. So where a contract of sale is not severable means which cannot be separated or cut off and separated, and the buyer has accepted the goods or part thereof, the breach of any condition to be fulfilled by the seller can only be treated as a breach of warranty and not as a ground of rejecting the goods and treating the condition as a repudiated unless there is a term of the contract express or implied to that effect. Now what let me take you example. So till just now we have discussed the case of car. So that case of car, the car cannot be divided into two parts. Okay, and either the car will be there or car will not be there, so it can be dealt in wholesale. It cannot be treated as a divisible item. So for example, A contracted B to supply 100 bales of cotton which he has to supply to C. Okay, now the supplying to C will be 100 bales of cotton and the other person was able to deliver only 95 bales of cotton. Okay, so now here for 5 bales of cotton, the person can repudiate the contract. Why? Because it was the condition of the contract that it has to be a full thing to be delivered. Okay, so now it totally depends on the buyer, whether if the buyer accepts the less amount and only files a suit against him for the damages and rest of the cotton bales he has taken, for which he has already given the money or has to give the money. So in this case, the condition can be treated as a warranty, and only the damages can be claimed. For example, the C file a suit against B for less supply of goods. So whatever is the suit of the damages can be claimed from A, because A has supplied less goods to B, which was to be supplied to C, and A knew this, that he has to supply full goods to C, but still he was not able to make the full arrangement of the goods, and that's why the C filed a suit against B. So in that case, A will be, and so the damages which is to be given by B to C can be claimed from A, because the goods are divisible. So nothing in this section can affect the case of any condition of warranty fulfillment of which is excused by law or the reason of impossibility or otherwise. So this is another thing. So in that case also it can be treated only as a the condition can be treated as a warranty. Further, section 13 specifies the cases where the breach of condition be treated as a breach of warranty, as a result of which the buyer loses his right to rescind the contract and claim for only for the damages. So in the following case, a contract is not avoided even on the ground of the breach of condition. So first is where the buyer altogether waives the performance of the condition. So the party may, for his own benefit, waive the stipulation. So sometimes it happens that the buyer he himself is waiving the stipulation. So in that case, because of, for example, the 100 bales of cotton to be supplied by him is actually suppose the market price has went down. So the person who had to accept the full quantity is now accepting only some quantity, because the seller was not able to supply the things to him, and now he is actually treating it. He is actually waiving it at, okay, you supply me less because the market price is less. So whatever loss of profit, loss he would be able to save, he can save that. So otherwise, if the full amount is received, then he has to sell it the entire full consignment of 100 bales at a very you can say less price. Otherwise, because market has gone down. Okay, so the buyer himself is treated as he has actually waived the condition. So where the buyer elects to treat the breach of condition as one of the warranty, so that is to say he may claim only damages instead of repudiating the contract. He has actually, so in this way also he has treated it as an he is treating the condition as a warranty. For example, A agrees to supply B 10 bags of first quality sugar at rupees 625 per bag, but supplies only second quality sugar at the price of rupees 600 per bag. So there is a breach of condition, because the quantity and quality both are less. Okay, and rate is less because of the quality is less. So there is a breach of condition. The buyer can reject the goods, but if the buyer so elects, he may treat it as a breach of warranty, accept the second quality sugar, and can claim the damages of 25 rupees per bag. Okay, so that can always be claimed as a damages. So less amount he's paying, that is okay, because he is now accepting 600 rupees, but he can claim the damages also, and those damages is to be paid by the seller, because he has breached the condition. Okay. Next is where the contract is non-severable and the buyer has accepted either the whole goods or any part thereof. Acceptance means acceptance as given under section 72 of the Indian Contract Act 1872. Okay, so it is where the contract is non-severable and the buyer has accepted either the whole goods or a part of it. So for example, a car is there, okay, and the person is actually has accepted the car in a whole. Suppose, for example, there is a contract of the car of second-hand car to be purchased. So in that case, what happens, that there may be some defect, but still the other person has accepted the car as a whole, and in that case he has actually treated the condition as a warranty. where the fulfillment of any conditional warranty is excused by the law for the reason of impossibility. If something is impossible or otherwise it is being done, then in that case the contract can be, the condition is said to be waived off. Okay, so waiver of condition can be two types: voluntary waiver of conditions, where the waive the performance of the contract and elect to treat the condition as a warranty. This is a voluntary waiver to be done on the part of the buyer. So compulsory waiver, when the non-severability of the contract is there and fulfillment of condition is excused by law. So the things given over here in this section, the four things are there. First two things in the section 13 are voluntary. Okay, and third and fourth are compulsory waiver. So this actually section deals with the waiver. Okay, next is your condition and warranties may be either express or implied. They may be express when the terms of the contract expressly state them, and they may be implied when it is not being expressly provided for, but it is by the conduct of the parties or the nature of the contract itself. So express conditions are those which are agreed upon between the parties at the time of contract and are expressly provided in the contract. So implied condition, on the other hand, are those which are presumed by law to be present in the contract. It should be noted that the implied condition may be negated or waived by a express. So express is always having a superseding power than implied. So something is implied. If it is expressed, then it can be waived off because something is expressed is more powerful than the things which are implied. So let us just talk about implied conditions. So there are various types of implied, 7 types of implied conditions are there. So following conditions are implied in contract of sale unless the circumstances of the contract show a different intention. So suppose, for example, condition as to title of the sale, sale by sample is there. Further condition as to quality and fitness, condition as to wholesomeness, condition as to description, sale by sample as well as by description. Okay, and condition as to merchantability, or you can say sellability of the goods. Let us just discuss this one by one. In every contract of sale, unless there is an agreement to the contrary, the first implied condition on the part of the seller is that in case of sale, he has right to resell the goods further. Okay, and this right is available to him only if he is having the not only the possession but the ownership of the goods. So in case of the agreement to sale, he gives the right to sell the goods at the time when the property is yet to pass. So condition as to title means, the condition as to title means a goods which is being sold from one person to another, the another person will be having all the rights of ownership on that goods, and ownership rights can be there only when the title is clear. Means a thing which has been theft or has been taken away from somewhere by coercion or undue influence or whatever, if sold further, will not give the further seller also a good title. There will be a maxim called namo dat quo non habet. So that is one which we'll be going to discuss also further. So in simple words, condition implied is that the seller has right to sell the goods at the time when the property is to pass. So seller himself is he is not having the right of selling the goods, means if his own title is not clear. So if the seller's title turns out to be defective, the buyer must return the goods to the true owner and recover the price, so he can repudiate the contract and also claim the damages. So this is the implied condition, that a person who is going to sell the goods to someone else must also have a clear title on those goods. Okay. For example, A purchased a tractor from B who had no title to it. So B actually got the title. The tractor was stolen. So he has actually, A has purchased from B a stolen tractor. So after 2 months, the true owner spotted the tractor and demanded it from A. Held A was bound to hand over the tractor to the true owner, and that A could sue B, the seller, without the title for recovery of the purchase price. Okay, so this is a very good example of the title. So next is if A sells to B tins of condensed milk labeled CDF brand. Okay, so this is some, you can say some brand is there. So ABCD some brand, and this is proved to be an infringement of N's company trademark. It will be a breach of implied condition that A had right to sell to them. So B in such a case will be entitled to reject the goods and take off the labels and claim the damages of the reduced value. If the seller has no title, the buyer has to make over the goods to the true owner he will be entitled to refund of the prices. Okay, so title in the goods is very, very important. Next condition is, implied condition is sale by description. So what is sale by description? So where there is a contract of sale of goods by description, there is an implied condition that the goods shall correspond with the description. So if you are selling something with the description, that it should actually resemble with the description. So this rule is based on the principle that if you contract to sell peas, you cannot compel the buyer to take beans. So अगर आप मटर बेच रहे हो तो you cannot just compel the buyer, okay, तुम राजमा खरीद लो. So it is something like that. So buyer is not bound to accept and pay the goods which are not according to the description of the goods. Thus it has to be determined whether the buyer has undertaken to purchase the goods by the description. That is, whether the description was essential for identifying the goods where the buyer had agreed to purchase. If that is required and the goods standard do not correspond with the description, it would be the breach of condition and entitling the buyer to reject the goods. Okay, so if the goods are to be given as per description, so it should resemble the description, otherwise buyer is having a right to repudiate the contract. So it is a condition which goes to the root of the contract, and the breach of it entitles the buyer to, number one, reject the goods and also claim the damages. Whether the buyer is able to inspect them or not, that is totally a different thing. So here the opportunity of inspection is totally, is secondary. Why? Because the goods must resemble the description, and description needs a description means it is proven that the thing is known by that name in the normal parlance of the general market. For example, A at Kolkata sells to B 12 bags of waste silk, okay, on its way from Murshidabad to Kolkata. So there is an implied condition that the silk shall be such as is known in the market as a waste silk. If it is not, then B is entitled to reject the goods. So these examples are all the cases which are real ones. Okay, so the things must actually resemble what is called waste silk in the normal market. So if it is not there, then it can be repudiated or rejected. Next example, you can say a ship was contracted to be sold as a copper fastened vessel. Copper fastened means the copper coating is there so that it should not rust. But actually it was only partially copper fastened. Hence the goods did not correspond to the description, hence could be returned, or if the buyer took the goods, he could claim the damages for the breach. The act, however, does not describe description. So it has not been defined. Description is not defined, but description is a description. We can understand what the description can be. So there is no need to define it even. So a sale is said to be by description where the class or a kind to which the goods belong as specified. Example, Egyptian cotton, Java sugar, Sheffield crockery, etc. And where the goods have been described by certain characteristics essential to their identification. Example, jute bales of specified shipment, steel of specific dimensions. Okay, so these have to be in the general market, in the normal parlance. It will be there in the normal parlance in the market, and accordingly will be treated as such. So it may be noted that the description in these cases assumes that the form of a statement or representation as regard to the identity of a particular goods by reference of the place or origin or the mode of packing, etc. This should be clearly. For example, basmati rice. Okay, suppose for example, Kota Doria. Okay, so something like that. So it should actually has a resemblance either for that particular thing or place from where it is there. So whether or not such a statement of representation is essential to identify the good, because it can be identified by anyone. So it is not necessary that the buyer get a chance to even sell it or even see it. For example, on phone, if he says that I need some basmati rice, so the rice must be basmati as such. It cannot be any other rice, okay, which is to be supplied. Next is sale by sample. So in the contract of sale by sample, there is an implied condition that the bulk shall correspondent with the sample in quality, and the buyer shall have reasonable opportunity of comparing the bulk with the sample. These two things must be there. So this is something which is different from sale by description. In sale by description, there is no need of sample, but in sale by sample, there is a need of, number one, it should resemble the sample, and secondly, the other person is having a reasonable opportunity of comparing the bulk with the sample. For example, I just contacted with someone to just supply me basmati rice. Okay, so that basmati rice, the other person is saying that, okay, sir, I have some samples of basmati. You please see what sample, and whatever sample you approve, I will be sending you that. And I went over there and I just see the sample. Actually, sample was resembling the bulk. I took the sample from the bulk only. And then I told that, okay, you send me this bulk, and took the sample along with me. Then afterwards, I found that the bulk which he has sent is not resembling with the sample which he has given to me. So in that case, you can say repudiate the contract or cancel the contract and claim the damages both. Okay, so the buyer must be having a opportunity to see the sample in that case. So in case of a sample of the two parcels of wheat, the seller is allowed, the seller allowed the buyer to inspect the smaller parcel, but not the larger parcel. In this case, it was held that the buyer was entitled to refuse to take any latent of the parcels of the wheat. Okay. So the sample, smaller sample, because sometimes buyer can tell you, okay, because it is already packed, packing kholna padega, ye hai wo hai. So do not just go on with all these excuses. You must see whatever is in the, because larger packet definitely may be having something in between. There may be something outside, or there may be something else inside. So that has the proper opportunity to inspect the entire bulk. If you are purchasing the goods in bulk, must be there. So the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent from the reasonable examination of the sample. This condition is applicable only with regard to the defects which could not be recovered by ordinary examination of the goods. But if the defects are latent, then the buyer can avoid the contract. So there are two types of contract. One is a latent contract and another is a patent. Patent, which can be seen by the normal eye, it is prima facie can be seen. And even if seeing those things, the buyer is purchasing the goods, then he cannot repudiate the contract. But there are certain defects which are latent in nature, which are hidden. So if the buyer and the seller is knows about it, and buyer is not at all able to inspect that by his normal eye, so he can actually, he can repudiate the contract at that time, because he cannot just see it with the normal eye, but the defects are there. Okay, for example, a company sold shoes made of special sole by sample for the French army. The shoes were found to contain paper not discoverable by the ordinary inspection. Held the buyer was entitled to refund the price plus damages also. Okay, so this is one case. So next is sale by sample as well as by description. So where the goods are sold by sample as well as by description, the implied condition is that the bulk of the goods supplied shall correspondent with both sample and description. In case the goods correspondent with sample but not tally with the description, or vice versa, or both, the buyer can repudiate the contract. Okay, so there is a example given. A agreed with B to sell certain oil described as a refined sunflower oil, warranted only equal to sample. The good standard was equal to sample but contained a mixture of hemp oil. So B can reject the goods because it is not as per the description. There is description, but it is also compromised. Next is quality as to fitness of goods. So ordinarily there is an implied condition as to quality of the fitness of goods for any particular purpose. However, the condition as to reasonable fitness of the goods for a particular purpose may be implied if the buyer had made known to the seller the purpose for which he is purchasing the goods, and he is actually relying on the skills and the judgment of the seller for selecting the goods which best suits his purpose. Even this implied condition will not apply if the goods have been sold under a trademark or a patent. So if there is some goods of certain trademark or patent, so it is well known that what purpose this patented or trademark goods will solve. Okay, but at the same time, if the goods are normal, you can say without any patent or without any trademark, or you can say the open goods, then, and the buyer is relying totally on the seller's skill and his judgment that the goods will suit. For example, I have told my purpose, at this purpose I just want certain things, and I am relying on the seller that, okay, fine, you just give me the goods which best suits my purpose. and he gives me certain thing and which is not at all in line with what I have told him, then I am having a right to repudiate the contract. For example, A bought a set of false teeth from B, a dentist, but the set was not fit for A's mouth. A rejected the set of teeth and claimed a refund of price. It was held that A was entitled to do so, as only the purpose for which he wanted the set of teeth were not fulfilled, because he actually relied on the dentist that whatever suits me, whatever is best fit for me, please supply me that. But the dentist supplied him some lower grade type of thing, so he is entitled for the refund of the price. Next is A went to B's shop, asked for a merit sewing machine. Now B gave A the same merit sewing machine was given, and A paid the price. A relied on the trade name of the machine rather than on the skill and judgment of the buyer. In this case, there is no implied condition because he has asked for certain branded goods. Okay, so in this case it will. So as a general rule, it is a duty of the buyer to examine the goods thoroughly before he buys them, in order to satisfy himself that the goods are suitable for his purpose for which he is buying them. This is known as the doctrine of caveat emptor or rule of caveat emptor, let the buyer beware. But at the same time, if he has given his conditions that I want goods for this and this purpose, then those conditions should be fulfilled in the way it has to be fulfilled, otherwise not. Okay, so this is the thing. So next is condition as to merchantability. Merchantability means that is actually which is sold in a good condition, or in a normal parlance of market it is sold. Okay, so where the goods bought by a description from a seller who deals in the goods of that description, whether he is manufacturer or producer or not, there is an implied condition that goods should be merchantable, or you can say it is sellable in the market. Okay, so provided if the buyer has examined the goods, there shall be no implied conditions as regard of defect, such as examination ought to have revealed. So if you can reveal any defect and at that time itself, even if if it is related to merchantability, you cannot repudiate the contract afterwards because the things are in front of you. Okay, so the expression merchantable quality, it has not been defined, it but it connotes that, or it denotes that goods of such a quality in such a condition, a man of ordinary prudence would accept them as a goods of the description. It does not imply a legal right or legal title to sell. It is not like that. So title and this is nothing to do with merchantability. Okay, so there is nothing regarding legal right or legal title to sell but the goods must be properly merchantable, or you can say it should be properly sellable. For example, even the packing is a merchantability. So if a person orders motor horn from a manufacturer of horns, and horns supplied are scratched and damaged owing to bad packing, he is entitled to reject them as an unmerchantable. So sometimes you may have received some parcel from Amazon which is not at all properly packed. So in that case, you can repudiate the contract. Okay. So A bought a black velvet cloth from C and found it to be damaged by white ants. So held the conditions as to merchantability was broken because it is unfit. Next is wholesomeness. So there is a difference between merchantability and wholesomeness. Wholesomeness is actually more normally related to, you can say, the eatable items, whereas merchantability is something which is marketability. So in the case of eatable and provisions, in conditions to the implied condition as to merchantability, there is another implied condition that it should be wholesome. So merchantability condition must also be there, and wholesomeness must also be there in case of the items which are eatables or food products. So A supplied F with the milk. The milk contained typhoid germs. So F wife consumed the milk and was infected and died. Held there was a breach of condition as to fitness, and A was liable to pay the damages. You might have seen these type of things in the normal parlance of market also, that someone dies just because of contamination. So there is a breach of condition of wholesomeness. Okay. Next is your implied one. So these all were the implied conditions. So now there are implied warranty. Warranty, it is a warranty which the law implies into the contract of sale. In other words, it is a stipulation which has not been included in the contract of sale in the express words. The law presumes that the parties have incorporated into their contract it will be interesting to know that the implied warranties are read to into every contract of sale unless they are expressly included by the express agreement of the parties. Okay, so these may also be excluded by course of dealings between the parties or the usage of the goods. So implied warranties are certain things which have to be which are not expressly included. Okay, so there are four types of implied warranty: warranty as to undisturbed possessions. Next is warranty as to non-existence of impermanence. Third is disclosure of dangerous nature of the goods and warranty as to quality and fitness of usage for the trade. So here you will see, you will find a very little difference between implied condition and implied warranty. But the conduct of the contract will only tell you whether there is an implied condition or there is a implied warranty. So the examination of section 14 and 16 of the Sale of Goods Act discloses the following are the implied warranties. First is warranty as to undisturbed possession. So undisturbed possessions means though a person may be having a good title to the goods, but the good title are also sometimes disturbed. Okay, so implied warranty that the seller have to enjoy a quiet position. Quiet position means it is free from all the other disturbances. That is to say, if the buyer having not having got a position of the goods, it is later on disturbed in his possession, he is entitled to sue the seller for the breach of the warranty. Okay, so warranty has to, for example, a pledger has pledged the goods to the pledgee, and pledgee has given the notice to the pledger, but pledger has not at all replied to the notice, and pledgee has sold the goods to someone else, assuming that he will, and then afterwards that pledger also came. Okay, and he claimed the goods that see this the goods are having my title. How come you are? So pledger is having a good title because he has given the on notice, but the person who has actually purchased the goods, he never knows about it. That this is something, pleasure and pledge is something that has happened. So he is having all the right to claim the damages from the pledgee. Okay, so but here the title is clear, but still there is some disturbance in that title. Further, warranty as to non-existence of incomeness in encumbrances. So an implied warranty that goods shall be free from any charge or encumbrances in favor of any third party not declared or known to the buyer before at the time of the contract he has entered into. So encumbrances and disturbances mostly are, almost similar. Okay, so it is so see again this pledge thing has come. A pledges his car with C for a loan of rupees 15,000 and promises him to give the possession next day. So A then sells the car immediately to B, who purchased it on good faith without knowing the fact that there is a 15,000 involved. Okay, so B may either ask to A to clear the loan himself or may pay the money and then file a suit against him for the recovery. So there is, and along with the recovery of the loan, he can file a suit against him for the damages also. So here is the implied warranty that it should be free from the, you can say, it should be free, the title should be totally good. Next is warranty as to quality of fitness and the usage of trade. An implied warranty to the quality of fitness or the particular purpose may be annexed to attach by the usage of the trade. So it can be the way it is being used. It is that's the way it will be treated. So next is regarding implied conditions warranty of the this fitness or any particular purpose of the goods supplied. The rule is that let the buyer beware. Okay, the seller is under no duty to reveal the unflattering truths about the goods sold, but this rule is this rule is having certain exceptions. So we will be studying this doctrine of caveat emptor in which all these things will come up. Next is disclosure of dangerous nature of the goods. If the goods are dangerous in nature, the buyer and the buyer is ignorant of the danger, the seller must warn the buyer about the probable danger if there is a breach of warranty, if the seller is not at all telling the buyer regarding the damages. Okay. Next is your doctrine of caveat emptor. Let the buyer beware, because in caveat emptor what happens that you have you have one condition, let the buyer beware. So when we give the buyer an proper opportunity to inspect the goods and we tell him clearly that whatever is there, it is in front of you, whether you want to purchase it, it's yours, which if you do not want to purchase it, it's mine, no problem. So this is thing, and then afterwards there is no warranty, no guarantee of the things. Okay, So whatever is there, it sells. Like Chinese goods. So people do not give guarantee warranty for the Chinese goods. They even sometimes they say that even after you leave the shop, it may not work. So it is all yours. It is not mine. So that is so you must inspect the goods at the time when you are purchasing it, and then afterwards you cannot claim that the goods are damaged. So this is called doctrine of caveat emptor. That is the let the buyer beware. But there are certain exception to it. Okay. So there are the following are the conditions to be satisfied in order to have this. Okay, if the buyer had made known the seller the purpose of his purchase, so there is are certain exceptions. So if the buyer has told the seller that this is my purpose and this is for which I want to purchase the goods, then this doctrine of caveat emptor will not be applicable. Next, the buyer has relied on the seller's skills and judgment for purchase of his goods because he has already given, though the seller has given a proper opportunity, but still the buyer has told that see my purpose is this, now you tell me whether should I take the goods or not. So he totally relying on the seller. Okay, seller's business to supply the goods of that description. Seller is actually normally supplying the goods of that description, and buyer has purchased it relying upon him. For example, A sold pigs to B, and pigs being infected caused the typhoid to the other healthy pigs of the buyer. It was held that the seller was not bound to disclose that the pigs were unhealthy, the rule of law being the caveat emptor, because the person who is really dealing in the goods, because he himself was having pigs, so he must actually see whether the pigs are infected or not, or he must have got the doctor to get the pigs checked whether they are infected or not. Okay, so here is the doctrine of caveat emptor. So A purchased horse from B. A needed the horse for riding, but he did not mention this fact to B. So the horse is the horse is not suitable for riding, but it is suitable only for being driven as a cart. So horse is a horse. Okay, horse doesn't always mean that you sit on it and you ride it. It can be for the carriage also. Okay, so he has not actually. So he tried to sit on the horse and horse died. So the caveat emptor rule applies here, and so A can neither reject the horse nor can claim for the compensation because the horse was for the carriage purpose. But had he been asking the horse that I need horse for riding purpose, and the B would have supplied the horse which is not for riding purpose, in that case, he will be responsible. There are clear exceptions to this, that fitness as to quality of use is there. So okay, so this doctrine of caveat emptor and the case related with this particular thing we will be discussing tomorrow. Okay, though otherwise I was supposed to discuss this today, but we'll take it tomorrow and onwards. Okay. So doctrine of caveat emptor and onwards we will be discussing tomorrow. Fine. So let me take the attendance. Exceeded 2 minutes. Yeah. So Chandresh Kumar Sigar, Vrishti Verma, Arshit.
Present, sir.
Arshit, Hemant Kumar Katik, Rakesh
Yes,
Rathi,
sir.
Shekhawat, Banan Goyal, Matan Sharma, Mukul Swami, Parth Narendra Bhai, Prakash Chaudhary, Puneet Jha,
Present, sir.
Yes, sir.
Pal Singh,
Yes,
Rahul
sir.
Kevadia, Rakesh Raika, Ravi
Present,
Present,
Ranga,
sir.
sir.
Rohan Modi, Rohan Pingle, Sandeep Singh Bhati,
Yes,
Tarush
sir.
Mittal, and Tirthak Kirtibhai Phataria.
Yes,
So
sir.
these are the students who are present
So
in the.
I am also present, Khushi.
Khushi, yeah, I told Khushi Shekhawat, I announced your name.
Okay, sir.
And I announced your name thinking that yes, you are there. Okay, but you didn't spoke at that time. It's okay. Announcement is merely an announcement is okay. No problem in that. Okay. So all the best and have a nice day to all of you. Take care. Goodbye.
Thank you, sir.